5 seconds to go. Start. In the present case, the record before the court indicates that the check was drawn by the appellant for Lakshmi Cement and Ceramics Industries Limited, as its director. Stop. A notice of demand was served only on the appellant. Stop. The complaint was lodged only against the appellant without arraigning the company as an accused. Stop. Para. The provisions of section 141 postulate that if the person committing an offence under section 138 is a company, for 2018 13 SC 663, every person, who at the time when the offence was committed was in charge of or was responsible to the company for the conduct of the business of the company, as well as the company, shall be deemed to be guilty of the offence and shall be liable to be proceeded against and punished. Stop. Para. In the absence of the company being arraigned as an accused, a complaint against the appellant was therefore not maintainable. Stop. The appellant had signed the check as a director of the company and for and on its behalf, moreover, in the absence of a notice of demand being served on the company and without compliance with the proviso to section 138, the High Court was in error in holding that the company could now be arraigned as an accused. Stop. Para. This issue stands concluded by a decision of 3-judge bench of this court in the case of Anita versus Godfather Travels and Tours Private Limited, Supra, wherein it has been held that for maintaining the prosecution under section 141 of NI Act, arraigning of the company as an accused is imperative and non-impleadment of the company would be fatal for the complaint. Stop. It may be relevant to extract the following from the said judgment: para. Applying the doctrine of strict construction, we are of the considered opinion that commission of offence by the company is an express condition precedent to attract the vicarious liability of others. Stop. Thus, the words as well as the company appearing in the section make it absolutely unmistakably clear that when the company can be prosecuted, then only the persons mentioned in the other categories could be vicariously liable for the offence subject to the averments in the petition and proof thereof. Stop. One cannot be oblivious of the fact that the company is a juristic person and it has its own responsibility. Stop. If a finding is recorded against it, it would create a concavity in its reputation. Stop. There can be situations when the corporate reputation is affected when a director is indicted. Stop. Para. In view of our aforesaid analysis, we arrive at the irresistible conclusion that for maintaining the prosecution under section 141 of the Act, arraigning of a company as an accused is imperative. Stop. The other categories of offenders can only be brought in the dragnet on the touchstone of vicarious liability as the same has been stipulated in the provision itself. Stop. Para. The observations made in the aforesaid judgment is also a complete answer to the arguments advanced by the learned counsel for the appellant that in the absence of any prohibition under the NI Act, the amendment in the complaint is permissible and the impleadment of an additional accused subsequent to filing of the complaint, would not be barred. Stop.